The ACLU obtained internal IRS documents years later. They found that before Warshak, the IRS had a standing policy of reading Americans' emails without warrant. When asked whether it had changed that policy outside the Sixth Circuit, the IRS declined to say. That IRS detail isn't a one-off. The same access framework applies to civil agencies across the board. Agencies that have nothing to do with criminal law. And you never know it was happening until you received a notice you might not even understand. Because here's something most people don't realize about the ECPA. It isn't just a criminal law tool. The SEC, the FTC, the IRS, even civil enforcement agencies investigating civil violations, not crimes, can use the same subpoena standard to access old emails and cloud stored documents. You don't have to be a criminal suspect. You just have to be relevant to an investigation. Here's how it actually plays out. A federal agency opens an investigation. They identify accounts that might hold relevant communications. They send a subpoena to Gmail, Outlook, or Yahoo, or whoever you use for your email. The provider has to comply, and the government can request that notice to you to be delayed, up to 90 days in civil cases, longer in criminal. And by the time you find out, the investigation is already underway and the evidence is already in their hands. And it extends beyond email. Documents in Google Drive, photos in iCloud, notes in Dropbox. Anything stored with a third party falls under the same Store Communications Act framework. The principle goes back to a case we covered called Smith v. Maryland. When you hand your data to a third party, your privacy protections shrink. Your email provider, your cloud storage, your phone carrier, all of them sit between you and the law. So the law has a real structural problem, but it also has protections people don't know they have. Understanding both sides of this is what actually matters.